I thought the letter in my mailbox had to be some kind of joke. A $1 million HOA fine for violations I never agreed to. But when I read the final line, my hands started shaking. They weren't just asking for money. They were threatening to take my house. What that HOA didn't realize was that their entire neighborhood was built on land my family still controlled. The certified envelope looked official. Heavy paper, legal stamps, the kind of letter that immediately makes your stomach tighten. At first I assumed it was junk mail pretending to be important. Then I saw the return address. Pinecrest Meadows Homeowners Association. I opened it standing in my driveway, still holding my morning coffee. The first paragraph made no sense. The second paragraph made my heart start racing. By the third paragraph, my coffee mug slipped from my hand and shattered on the concrete. The document listed 17 different HOA violations connected to my property. Unauthorized landscaping. Unapproved exterior paint color. Improper vehicle parking. Failure to maintain approved lawn standards. Each violation carried a fine of $500 per day. And according to the document, those violations had been accumulating for 5 years. At the bottom of the page sat a number that looked unreal. $1,247,500. Over $1 million. The letter ended with a final warning. If the fine wasn't paid within 30 days, the HOA would place a lien on my property and begin foreclosure proceedings. Which meant they could legally try to take my house. The only problem? I wasn't even part of the HOA. My house sat at the entrance of Pinecrest Meadows. It had been there since 1967, long before the neighborhood even existed. My grandfather built it himself. Back then the entire area was farmland. Decades later a developer bought the surrounding land and built 12 suburban homes. That's when the HOA was created. But my family never joined it. We kept our original 3 acres. The house still looked like something from the 1960s. A ranch-style home. A big vegetable garden in the front yard. And my grandfather's old pickup truck sitting in the driveway. To me it was family history. To the HOA president, Linda Vasquez, it was a problem. Ever since she became HOA president 2 years earlier, she'd been sending violation notices about my house. She said it lowered property values. She said it didn't match the community aesthetic. I ignored every single letter. Because legally, she had no authority over me. Or at least, that's what I believed. Until the $1 million fine arrived. I called my attorney immediately. Richard, I said, the HOA says I owe them over $1 million. There was a long pause on the phone. Marcus, you're not even part of the HOA. That's what I thought. I emailed him the letter. 2 hours later he called back. And his voice sounded different. Angrier. Marcus, this is one of the most aggressive HOA overreach cases I've ever seen. My stomach tightened. Apparently, he continued, 3 years ago Linda filed a lawsuit claiming your property should be considered part of the HOA development. What? How? She argued that because your driveway connects to the HOA access road, you benefit from their infrastructure. That's ridiculous, I said. I agree. But here's the problem. He paused. She actually won the case. My chest tightened. How is that possible? Because you never showed up to court. I sat down slowly. What do you mean I never showed up? The court notices were sent to an old address. Which meant the judge issued a default judgment. Without me even knowing about the case. And that judgment allowed the HOA to claim authority over my property. Which meant Linda had just found a legal weapon. The $1 million fine. But then Richard said something that changed everything. Marcus. I pulled the original property deed from county records. And there's something very interesting in it. An hour later I was sitting in Richard's office staring at documents from 1962. My grandfather's original deed. Back then he owned 17 acres. the entire land where Pinecrest Meadows now stood. In 1989 he sold most of it to a development company. But he kept our 3 acres. And buried deep in the contract was a clause no one had noticed for decades. A perpetual easement agreement. It said my grandfather retained legal rights over all access roads and shared areas built on the property. Those rights passed to his heirs. Which meant they passed to me. I stared at the paper. What does that mean exactly? Richard leaned back in his chair and smiled. It means the HOA has been operating for 15 years on land that technically requires your permission. Wait, what? The roads they maintain, the sidewalks, the clubhouse, all of it sits on easement land your grandfather reserved rights to. My brain struggled to process it. So when Linda says I'm benefiting from their roads. Richard nodded. She's got it backwards. They've been benefiting from yours. Richard drafted a letter to the HOA board. It explained everything. The easement rights. The property history. And one critical fact. Because the HOA never obtained written permission from my family, they technically had no authority to control those roads or common areas. Which meant they were operating without authorization. The letter ended with a warning. If the HOA didn't immediately drop all fines and retract their claims, I would revoke access to the easement. Which meant installing gates. Which meant cutting off the road leading to the entire neighborhood. Within an hour of sending the letter, my phone rang. Linda. She was furious. This is extortion, she shouted. You can't threaten to block access to people's homes. I stayed calm. Linda, those roads belong to my easement rights. You're insane. No, I said quietly. I'm just enforcing my property rights. 3 days later the HOA called an emergency meeting at the community clubhouse. The room was packed with confused homeowners. Linda stood at the front trying to explain the situation. She claimed I was holding the neighborhood hostage. But then something unexpected happened. One of the residents stood up. A man named Robertson. I'm a real estate attorney, he said. And I reviewed the documents. The room went silent. Mr. Williams is correct, he continued. The easement rights were never transferred to the HOA. Which meant I legally had the right to control access. Suddenly people started asking questions. Why did you try to fine him if he wasn't part of the HOA? Why did you file a lawsuit using an old address? Why is the entire neighborhood at risk because of this? The anger in the room shifted. Toward Linda. Because it was becoming obvious. This wasn't about protecting property values. It was about a personal grudge. The vote happened right there in the meeting. Unanimous. Linda Vasquez was removed as HOA president immediately. The board cancelled every fine against me. They issued a written apology. And they asked if we could negotiate a permanent easement agreement moving forward. I agreed. Because the truth was, I never wanted a fight. I just wanted to live peacefully in the house my grandfather built. But Linda's problems weren't over. Because my lawyer filed a separate case. For fraud and abuse of legal process. Facing serious legal trouble, Linda settled privately. She paid damages, resigned from the HOA completely, and sold her house a few months later. A few months later the neighborhood felt different. Friendlier. The new HOA leadership worked with me instead of against me. They repaved the road, this time with my permission. And at the entrance of the neighborhood they installed a small plaque. Original road built by George Williams, 1965. My vegetable garden stayed right where it had always been. And my grandfather's pickup truck still sat proudly in the driveway. The $1 million fine that started everything? Gone. Just like the person who created it. Because sometimes the people who try hardest to control others forget one important thing. They might not actually own the ground they are standing on. And when the truth comes out, the power shifts very fast.